Wait,
Okay, I guess we should be ready to start. Attendees are now coming in.
okay,
Webinar.
perfect.
Um, and to be respectful of every time and your time, I will just get started. So we just be punctual. Is that okay?
Yep, yeah, of course. Ready.
Nice. Good afternoon, everyone. My name is Madjeen Garcon, and I am one of the chairs of the Metropolitan Black Bar Association Young Lawyers Division, and I'm also the president of the Haitian American Lawyers Association of New York. Thank you so much for attending our second part of our two-part student loan discussion with the expert herself, Natalie. And we are going to continue discussion that started on September 6th, but this time we're going to dive deeper into the bankruptcy issue around student loans. For those who may not have attended the very first meeting, I would like to do a brief introduction to who Natalie Jean-Baptiste is, and so you can understand her background and how she ended up getting here. Natalie Jean-Baptiste first started her career a part of the Legal Aid Society after nearly a decade of private practice, where she specialized in consumer bankruptcy and student debt relief. Natalie is committed to economic empowerment and advocacy. She has a lot of success with discharging student debt in bankruptcy, which is notoriously difficult to do. In her new role as staff attorney for the consumer law, Natalie represents debtors in all 5 boroughs of New York City in Chapter 7 and Chapter 13 bankruptcy proceedings. She is dedicated to helping low-income New Yorkers resolve their debt problems and financial fresh start. Natalie earned a Bachelor of Arts in Communication and Media from Fordham University and her JD from New York Law School. She is also a member of the National Association of Consumer Bankruptcy for Attorneys and is also the recipient of the 2023 Henry J. Summer Scholarship. Thank you so much, Natalie, for hosting us, and we're going to turn it over to you. Anyone who may have any questions for Natalie, just put them in the webinar chat, and I will, if it's important and relevant to what she's currently discussing, I will feel free to jump in and ask a question on your behalf. But thank you so much, Natalie. You are good to go, and I know you're going to give us a wonderful presentation today. I'm excited to hear more about it.
Okay. Hi, welcome everyone. Thank you for having me. It's an honor to be here with you and teach you and impart my knowledge on you. So first I want to make sure I can share my screen. So let me just pull up the presentation. One moment. Okay, so just pulling up the PowerPoint. Okay, so are you guys good? Can you see the screen clearly? Okay, awesome. All right, so, as Madjeen said, we had part 1 2 weeks ago where I gave you guys all types of solutions on, managing or eliminating student loan debt. Tonight, we're going to focus on discharging student loan debt in bankruptcy, which is my superpower and what I'm really most passionate about. And I know the word bankruptcy can, scare a lot of people, and they, it's this thing that you don't know how it works, and it just sounds like something you just never would want to do. But I hope that when I get through my presentation, that you'll be more open to the idea, and perhaps, you can help yourself or someone you know. Okay. So first, we're going to start about why we're here, right? As the student loan debt crisis grows, more bankruptcy filers are seeking discharge of their student loan debt. And recent policy changes have made it easier to discharge student loan debt in bankruptcy by setting clear, transparent, and consistent expectations and simplifying the process. And this is for students who can't even afford the minimum payments on their student loans. This is for people who have defaulted on their loans, or are they're dealing with extenuating circumstances such as divorce or chronic illness, making it difficult or impossible to pay their student loan debt. And also anyone who is a student loan borrower who's facing lawsuits and garnishments and things like that. So the key takeaways are that those burdened with student loan debt can get a fresh start in bankruptcy. And then you'll learn about how student loans are treated in bankruptcy. They do get special treatment, and I'll go into the details of how that works later. And then you'll understand how to litigate the dischargeability of student loan debt, and the steps of filing an adversary proceeding. So I'll give you a roadmap of what it looks like to litigate student loan debt in bankruptcy. So first, I know Madjeen read my bio, but I want to give you like my story from my own words and my own perspective, right? And I just want you guys to get a sense of who I am and how I started doing this, right? So I am not some bankruptcy guru. I never set out to be a bankruptcy attorney. I went to law school because I wanted to party with rock stars. That's it. Point blank, period. I mean, I grew up always wanting to know, I'm always knowing I wanted to be an attorney, right? Because I grew up on the Cosby Show, right? And everybody, all the little Black girls wanted to be like Claire Huxtable, or at least the ones that I knew, right? So, but when I was applying to law school, I was very clear I wanted to be an entertainment lawyer. And I did successfully get my foot in the door at some of the biggest record labels in the world. And I worked for many years in the music industry, but not making the money that I wanted to make, not getting the roles I wanted to necessarily get. But I was enjoying myself. But behind, like, you know, on the outside, everything looked great. But on, you know, for my private struggle, I was struggling with my student loan debt as well as my consumer debt, right? So, you know, I'm almost a decade out of law school. My loans, even though I've been paying them consistently, I owe pretty much what I owed when I graduated, right? So I'm facing the possibility of filing bankruptcy, and I struggled with the decision for a long time. And when it was time for me to file, the attorneys were quoting me their fees, and my mind, like, it just made my head explode. So I came up with a brilliant idea that I was going to represent myself, right? So I just started, you know, reading everything I could get my hands on about bankruptcy law and teaching myself how to do it. So when I was, you know, learning bankruptcy law, I realized that there's this thing called the undue hardship exception, right? So basically, the general rule is that you can't discharge student loans in bankruptcy, and they give you this notion that it's impossible, you can't do it. But then when I read the statute, and I'll get to that later in the presentation, when I read the statute, I was like, well, this is me. Like, I can get rid of my student loans based on this criteria. So I naively decided that not only was I going to go through a bankruptcy, but I was going to litigate my student loan debt as well. And I am like the Elle Woods of this world, right? Because I had no idea what I was really in for, because I wasn't part of that world. And I didn't know how hard it would be. So I'm just like, I'm going to discharge my student loans in bankruptcy. Like, what? Like, it's hard? So I'm going through this process. People are looking at me like, who does this girl think she is? So, and like people who have been practicing this for years were discouraging me, telling me it's impossible, I'm wasting my time. But I'm here to tell you that impossible is nothing. And I successfully wiped out $120,000 of my student loan debt. So I tell you the story not to impress you, but to impress upon you that even when people are telling you something's impossible, or, you know, you think this is, like, I've heard this is hard to do. If you, like, I had this belief in my heart that I'm like, I need to be free of this debt. And I was persistent, and I stuck with it. And after my success, I opened my own practice doing this work. And I've been doing this work for over a decade now. I was in private practice for a long time, but about a year ago, I joined the Legal Aid Society as a staff attorney, doing the same exact work, and doing what I'm passionate about and what I love. So that's just a little bit about me. Now we'll go over what we're going to discuss this evening. So first, I'll lay the groundwork and explain bankruptcy basics for those of you who might not know anything about bankruptcy. So I just want to lay the foundation so you understand how it works. And then I'll get into the particulars of discharging student loans. So Section 523A8 is the section of the bankruptcy code that governs dischargeability of student loan debt. Then we'll talk about what a qualified education loan is, and this is with respect to private student loan debt. Then we'll talk about how to establish undue hardship and the criteria that the court looks for, drafting the pleadings, discovery, student loans in Chapter 13, and last but not least, we'll discuss the new DOJ guidance on the discharge of federal student loans. Okay, so first, some facts and figures. The total outstanding student loan debt in this country is $1.75 trillion. About 45 million Americans have student loan debt, and 92% of it is federal. One of the important distinctions that you need to understand before you pursue any relief of student loans, but bankruptcy especially, is that you need to know the distinctions between federal and private student loans. So for federal loans, the interest rates are much lower. There are flexible repayment options. There's loan forgiveness available. But on the flip side, there are serious default consequences. So if you default on a federal student loan, your wages can be garnished without a court order, and even like your Social Security, any type of federal benefits can be offset. Your tax refunds can be taken. So things like that don't happen with private student loans. And also on federal student loans, there is no statute of limitations. It will follow you to the grave. It could follow you to the grave. And also it's not tied to any credit worthiness. There's no cosigner ever required for a federal student loan. They're just handing them out like candy. The private student loans, on the other hand, the interest rates are much higher. Most of the time, there's no flexibility or income-based repayment available. And there are no loan forgiveness programs when it comes to private loans. And in the case of private loans, they have to litigate and win a judgment in court in order to collect on the loan. So they can't garnish your wages without a court order the way the federal government can. And there's always a statute of limitations. So in New York, the statute of limitations on the collection of debt is 3 years. And 9 times out of 10, a private student loan is going to be co-signed by a parent or a family member. Okay, so the way you identify the type of loan is by going to studentaid.gov. Once you sign in, you can see all of your loan information, the disbursement dates, the balance, the interest rates, the type of loan, etc. And then this is just a screenshot of what it looks like, where you're viewing the details of the loan. If the loan is not in that federal student loan database, it's most likely a private loan. And you can get that information from annualcreditreport.com, or you can pull each of your credit reports from each of the 3 bureaus. All right, so now let's discuss the basics of bankruptcy. So bankruptcy is a legal process established under federal law to allow people who can't pay their debts to eliminate the legal obligation to pay most or all of certain types of debts, to give them a financial fresh start. All right, so, and Article 1, Section 8 of the US Constitution authorizes Congress to enact uniform laws on the subject of bankruptcies. Under this grant of authority, Congress enacted the Bankruptcy Code in 1978. And the fundamental goal of bankruptcy law is to give debtors a fresh start from burdensome debts. All right. And bankruptcy is a court of equity. So not only is it providing a fresh start for debtors, it's also ensuring that all of the creditors are treated fairly, all of the similarly situated creditors. So if it's a secured debt, all secured creditors will be treated the same, priority debts, et cetera, et cetera. So keep in mind that, bankruptcy is a little different from, your traditional courts in that regard. The definition of bankruptcy is captured well in this 1934 Supreme Court decision. It says that bankruptcy gives the honest but unfortunate debtor a new opportunity in life and clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. And I think that student loan borrowers are the quintessential honest but unfortunate debtor. Most people start taking out student loans when they're 17 or 18, before they're even old enough to drink. So, it's one of those things that you take out this loan and you hope that it's going to open doors for you, and then it turns out to be more of a burden than it is providing you opportunities. Okay, so again, the goal is accomplished through the bankruptcy discharge. So the discharge is what releases debtors from personal liability on specific debts, and it prohibits creditors from ever taking action against that debtor. The debtor is no longer legally obligated to pay any of the debts that are discharged. There are two types of personal bankruptcy. Chapter 7 is the most common one for consumers, and this is where all of the debts are wiped away and there's no payment plan to repay them back. And most Chapter 7 cases are what are called no asset cases. This doesn't mean that the debtor doesn't have any assets, because most debtors have assets that are protected by exemption laws. So exemption laws are things like the homestead exemption, the vehicle exemption, meaning the law allows the person to keep those items and still discharge their debt. Okay. Chapter 13 is for people who usually are high earners and they make more than the median income in the state that they live in, and they have regular income to repay some of their debts. And Chapter 13 usually lasts anywhere from 3 to 5 years. Okay, so one of the beauties of bankruptcy is something called the automatic stay, right? So this is what stops all the collection efforts in their tracks the minute the case is filed. So all collection calls and letters must stop, lawsuits, wage garnishments, foreclosures, repossessions, all of that is instantly stopped once a case is filed, the minute the case is filed. Right? So I want to distinguish between dischargeable and non-dischargeable debts. So dischargeable debts are the ones that we normally think of when we think of debt. Credit cards, medical bills, personal loans, auto loans, payday loans. Non-dischargeable debts, for public policy reasons, means that even if you file bankruptcy, that these debts will stick. Right? So that includes taxes, child support and alimony, fines and penalties, any debts related to drunk driving, and student loans. Okay. Chapter 20 is a term that bankruptcy attorneys use when they're going to do two cases, a 7 and a 13. And this is a great way to manage student loan debt if you're not going to litigate the dischargeability of student loans, right? So first you file a Chapter 7, you wipe out all the dischargeable debts, credit cards, medical bills, etc. And then you file a Chapter 13 to propose a manageable payment plan to manage the debt, even though you may not qualify for what they call the undue hardship. Okay, so now we're getting to the section called 523A8, which is the section of the bankruptcy code that governs the dischargeability of student loan debt. So this basically, long and short of it, this is the actual statute language, but I'm not going to bore you with every single detail. Basically, if a person has a student loan that's either a qualified education loan or a federal student loan, they will not, the debt will not be discharged unless the debtor can show that it would impose what's called an undue hardship. Okay, and I'll get into the particulars of what undue hardship means. Okay, so the legislative intent of 52388 is to prevent undeserving debtors from abusing the student loan program, right? And this was sort of more preventative. They didn't want people graduating with, especially graduate degrees, and then running to bankruptcy court after they got a law degree or a medical degree. So it was sort of just preventative, so they implemented that rule. And they wanted to preserve the financial integrity of the student loan program. And I guess that was, a worthy goal back then, but I argue that the student loan program lost its integrity a long time ago. So there's that. So the rules indicate that you must file an adversary proceeding in order to get rid of the student loan debt. It's not going to be automatic, right? So bankruptcy is an administrative process where basically you submit the petition and the schedules, and then you go through the process, and the loan will be discharged once the judge signs off on it. But student loans, they have to take the extra step of filing the adversary proceeding. And also an old bankruptcy case, if you have, for some reason, pursued bankruptcy in the past and didn't discharge student loans, the law allows a debtor to reopen a case at any time to litigate student loans. Okay, so the adversary proceeding means that, the student is the plaintiff and the defendants are anybody who owns their student loan. So it could be the Department of Education or any of the private lenders. Okay, so one of the most important parts is identifying the right defendant, figuring out, like I said, who owns the loans. Is it the federal government or a private lender? And naming the proper parties. And you can find out who the lender and the servicer is by logging in to studentaid.gov or pulling the credit reports. Okay, so when the case is filed, you have to serve the summons will be issued, and you serve a copy of the summons and complaint on all the parties. And there are special rules for serving the U.S. government. The Attorney General has to be served, and the U.S. Attorney's office in your district. Okay, so now let's talk about qualified education loans, because there are many private loans where they don't fit the definition and the criteria of what the law deems a student loan, right? So a qualified education loan is a debt that's incurred solely to pay for qualified higher education expenses at an accredited institution by an eligible student. All of those factors must be present in order for it to qualify as a student loan. Okay, so some schools are not even eligible, right? So it has to be on the Department of Education's Title IV eligibility school list for the year that the student attended. There are many instances where there are foreign medical schools and it's unlicensed and unaccredited, so any debt incurred to pay for that school would be dischargeable. Flight schools, so a lot of these flight schools or tech schools are not eligible institutions, and the debt is dischargeable. Bar study loans, this is important for this audience. is these are dischargeable because it's not an educational benefit within the meaning of the bankruptcy code, and it was dischargeable. This is actually a Brooklyn case, Campbell versus Citibank. So let's define what an eligible student is. You have to be a US citizen or permanent resident, enrolled at least half-time, and for males, be registered with Selective Service and have a high school diploma or GED or passed what they call an ability to benefit test. So qualified loan is a loan that's used solely for qualified education expenses. So if it's a mixed loan, that's not going to qualify. And that would include tuition and related expenses like student activity fees and things like that, as long as it's required by the school. Okay. So when we're talking about private student loans, the burden is on the creditor to establish that the debt is an educational loan. Okay, so they're the ones who have to prove that it meets all of the criteria that I just explained. So these are two examples where it's not an educational loan. So anything incurred for housing, transportation, living expenses are not qualified education expenses. Okay, so if somebody borrowed private student loan money and took vacations or bought a car or just used it to buy groceries and Metro cards, that if they can prove that that was not used to pay tuition or student activity fees, then that loan is dischargeable. And also I want to distinguish between a loan and unpaid tuition. So a lot of students have debts to the school directly, right? So there's a bill, there's an unpaid tuition bill, and the school will sue, or that'll be listed as a debt. You do not have to bring an adversary proceeding to discharge that debt because unpaid tuition is not a student loan. So there's a difference there. It's important to note that. Okay, so when we're talking about private student loans, the cost of attendance is important. So the cost of attendance is determined by the school, and it includes tuition, books, room and board, and each school has the cost of attendance published for that academic year. So if the loan, first of all, the lender has to get certification from the school about the cost of attendance. And many of them just bypass the financial aid office and lend directly to students. And that's not okay, right? So especially if it exceeds the cost of attendance. So any amount that's lent in excess of cost of attendance is not a qualified loan. So even if they lend you $5 more than what the cost of attendance was, the entire loan becomes dischargeable at that point. And this is specifically for private student loans. Okay, so this is a few examples of quote unquote dischargeable student debt, right? So credit card debt incurred by a student, loans for unaccredited programs like a bar exam course, unpaid balances owed directly to the school, K through 12, because sometimes, there's a fancy boarding school and the child or the parent will borrow money for that educational expense, and that is not a qualified loan. And a lot of the overseas schools are unaccredited. Okay, so drafting tip for the complaint. If there's any doubt as to whether or not the loan is a qualified loan, when we're talking about private loans, do not plead facts in the complaint that say it's a student loan. And then also when filling out the schedules, you don't want to designate it as a student loan obligation because in the schedules for the bankruptcy, you have to indicate what type of debt it is. And if there's any question mark there, do not check the student loan box. Okay, so this is really the heart of this presentation and what you guys need to understand as far as what makes a student loan dischargeable and what undue hardship is, okay? So In the majority rule is what we call the Brunner test, right? So there are three main criteria for the Brunner test. So the first one is that the debtor cannot, based on their current income and expenses, maintain a minimal standard of living for himself or herself and his or her dependents if forced to repay the loans. Number two is that there are additional circumstances indicating that the state of affairs is likely to persist for a significant for a significant portion of the repayment period. And three, that the debtor has made good faith efforts to repay the loans. Okay, and this is under a 1987 New York case, Brunner versus New York State Higher Education Services. Okay, and the minority rule in some jurisdictions is what they call the totality of the circumstances test. So here, the bankruptcy court must consider the debtor's past, present, and reasonably reliable financial resources, and then a calculation of the debtor's and her dependents' reasonable and necessary living expenses, and any other relevant facts and circumstances surrounding each particular case. Okay, so these are a few factors of the totality of the circumstances test. I won't go through all the factors, but you can refer to this slide later of what the court looks at in this jurisdiction. It's not a rule here in New York, so I won't spend too much time on it. Okay, so let's talk about how the Brunner test is applied, right? So the first prong is the minimal standard of living prong. So we look at, are the debtor's expenses reasonable, right? And it's been established that reasonable standard of living or minimal standard of living would include decent shelter and utilities, food and personal products, vehicles maintained, insured, and tagged, health insurance or the ability to pay for medical and dental expenses as they arise, and at least a small amount of life insurance, and funds for recreation like cable or pet. And this is just a few cases where it illustrates how this standard is applied. So you could refer to this slide later. All right, again, this is just a list of what the court looks at when they're considering your reasonable and necessary expenses, right? So first, food, housing, utilities, your basic communication, so that would include internet and basic phone service, any necessary medical and dental, any necessary insurance, transportation, childcare, and then paying child support or alimony. Now, what the court deems as luxuries, even though in the real world, these are not luxuries, these are things that most everyday people have, like, if they're dining out, right? So even if it's not a fancy restaurant, but if there's evidence that they're dining out a lot, a gym membership, premium cable, premium cell phone service, any salon, spa, cosmetics. I've been in depositions where the opposing counsel will literally go through each charge at, Sephora or a spa or like concert tickets, right? So anything from Ticketmaster will be looked at as luxurious living, right? And money that the student loan lender that you could be paying back, right? Any trips to the liquor store, vacations, so things like that are looked at as luxuries when it comes to evaluating your monthly budget. Okay, so the second prong of the Brunner test is discussing additional circumstances, right? Circumstances that exist for the debtor that are likely to persist for a long time. So they look at how long, the problem is expected to last. If there's a chronic illness, it has their earning capacity peaked. Did the person not even obtain the degree that they went to school for? Hi, Madjeen, did someone have a question?
Yeah, someone has a question and I wanted to like be able to ask the questions. Actually, it's quite a few questions. I don't know if you're okay with taking quite a few.
Yeah, sure. It's better to take it while we're on topic.
Okay, awesome. The first question is they just want to be clear that discharging federal student debt in bankruptcy is possible, but it's very difficult.
Yes and no. So it is possible. It has been possible for a long time. It's just that people weren't talking about it. But in November of last year, there was new guidance issued by the Department of Justice and the Department of Education that made the process a lot more clear-cut and simple and easy. Again, people are still not talking about it as much as they should, but it's very straightforward and a lot easier than the way I've been doing it for almost a decade, which is like moving a mountain. But now it's very simple, and I'll go through what it looks like now, and I'll get to that. That's like the last part of the presentation. But it's absolutely not impossible, right? Because when I did my case in 2013, people told me I was wasting my time. You have a law degree, you're working, you can't get rid of your student loan debt. It's for like, if you have one foot in the grave and, like you're, a blind paraplegic, like those are the people who get rid of student like it. So they made it seem like it's absolutely a waste of time and impossible. So it has gotten a lot easier over the years, but in November of 2022 is really when the game changed. So now it's a lot easier. So I hope that answers the question. Sorry, that was a long way of answering the question.
I think that definitely answered the question. And I think this one's more on brand with what you just presented. The person asks, I understand there's a homestead and vehicle exemption, but can you be specific at what exactly you can keep and what would you have to liquidate? Is there any situation where I could sell my home or my car?
Right. Okay. So in New York, the homestead exemption, well, at least in the 5 boroughs, Long Island, Westchester, the homestead exemption is very generous, right? So it's about $180,000 per person. So it doesn't mean that your house is worth 180. It could be worth more than that, but you can't have more than $180 of equity in the home. Otherwise, you either would have to do a Chapter 13 where you're proposing a payment plan, right? Because in Chapter 13, you get to keep non-exempt property. But there's also a vehicle exemption. It's about $5,000. So remember, it's the equity in the car, not necessarily the value of the car. There's also cash exemption. Oh, like you can have $1 million in your retirement account and still do a Chapter 7 bankruptcy. There's exemptions for all sorts of things like household goods, electronics, life insurance, all kinds, but most people are concerned about their house and their car. So the thing is, we have this misconception about bankruptcy that if you file bankruptcy, you have nothing, right? Like you're losing the shirt off your back. It's not like the movies where you see them carrying furniture out of people's houses. Like that's not how it works, right? I think they do that for dramatic effect in the movies. But so yeah, I mean, if you want further clarification, I hope that answers the question. But yes, you can have a house, have a car, do not sell it before your bankruptcy because the law allows you to keep those things and still kick Sally Mae to the curb.
As a follow up to that question, they said, do you have to liquidate anything at all in Chapter 13, or is it a 3 to 5 year payment plan?
So you don't have to liquidate anything, but you have to pay back at least what the creditor would have gotten in a Chapter 7. So if there's anything above that's not exempt, like I don't want to get into like too much of the nitty gritty, but In Chapter 13, most of the time there's no liquidation involved. As long as there's a proposed payment plan in place and the total amount of debt paid over time would cover any non-exempt assets. I hope that's clear.
And this one is a more specific question, and I do believe it's on brand. The person said the only debt they have is student and their mortgage, and they need to get rid of their mortgage because their student debt payment is killing them. They barely have any savings and not getting market pay and need to pay student debt while having a house and a car between her husband and them. Should they walk away with most debt discharge and a fair payment plan for the 3 to 5 years with minimal savings intact and a house and the car still in their name? So basically, I guess what they're asking is, if they were to proceed with the bankruptcy option, would they be able to walk away with their home and their car in their name while still having minimal savings to be able to make the payments under their payment plan?
Right. So just because you have a house and a car, I just want to be clear. Just because you have a house and a car doesn't mean that you should do a 13. You could qualify for a 7, right? If your income is below a certain amount and you don't have that much equity in the home. So if between you and your husband, you have, because remember, if you only own half the property, you only have 50% of whatever equity is in the house, right? So if there's $100,000 of equity in the house, your portion of that is 50,000, and you would be well below the allowed exemption, because remember, the homestead exemption in all 5 boroughs, Long Island, Westchester, is $180,000, right? So if you have less than that as your equity in the home, and you could potentially file a Chapter 7. But okay, so the question is, so like there's a lot going on there.
There's a lot going on in that question. Yep.
Hope I am okay. So if you do a 13, you can propose a payment plan that would cover the mortgage, and in Chapter 13, you can, if you're current on the mortgage, you can just continue to pay the mortgage company directly. But if you're behind on the mortgage, the Chapter 13 allows you more time to catch up on the arrears, right? Of whatever you like, if you're a year behind on your mortgage, 12 months of payments. So again, I don't want to get bogged down with like all the nuances of bankruptcy. So you guys can email me directly, and my contact information will be in the slides and in the last slide. But again, without giving like a whole course on bankruptcy, I just want to get people to understand that you don't necessarily need to liquidate anything in order to be eligible for this relief, because the exemption laws allow you the basics, right? Because if people, bankruptcy is supposed to give you a fresh start. So if you had to be without a home and a car, how are you supposed to get a fresh start, right? So the whole idea is for you to get back on your feet, and you need certain things to get back on your feet, like a roof over your head, a car to get to work, money in the bank, retirement, insurance, all the things. So.
And this is one last question that's more of a broader question. They basically said they just want to know what is the detriment of filing for bankruptcy and why more people are not attempting to file for bankruptcy.
Oh, I love this question. It's because people don't know what it is, right? Like divorce has negative connotations around it, but people know what divorce is. They know it's you getting away from the person you married. You don't want to be with them anymore. But bankruptcy, people, it's just the stigma around it and then people don't understand how it works. They're worried about losing their house or their car, or they think that certain things need to be in place. And the funny thing is, wealthy people use bankruptcy all the time with no qualms, right? But people of color, people who struggle, really financially low income people, first of all, they don't understand how bankruptcy works, and something about it, like, I don't know why us as a people, we hesitate to file bankruptcy. Like we feel like we have this moral obligation to pay debt. We have too much pride, all the things, it's just sad. And one of my missions is to really educate and empower people about bankruptcy, because it's not the end, it's a new beginning, it's a fresh start. And corporations do it all the time. Corporations will poison drinking water and have billions of dollars of lawsuits against them and file bankruptcy and get away scot-free. So it's the middle class, the low income people who really struggle, who could use the relief, who don't even know that it could help them, or they do, but they have too much pride to do it, right? And I struggled with that decision for a long time, because I'm like, I'm an attorney, I'm supposed to have it together, I'm out here partying with rock stars, I couldn't possibly file for bankruptcy, right? Like, I had all these hangups around it. I thought that somehow, it was improper, like with the bar, that you couldn't file. Like, I had all these notions that I made up in my head, and it was all crap. Like, lawyers file for bankruptcy all the time. And I was filing, not even knowing I could get rid of my student loans. I had a ton of credit card debt, a ton of medical bills. And I was like, I'm going to go through this. And then it was as I was already going through the process when I learned, I'm like, I could get rid of my student loans. Okay, let me try this. And I'm so glad I came out from a different world where I wasn't programmed as a bankruptcy attorney that student loan debt is not dischargeable, right? It's like I came in with fresh eyes and just reading the statute. And to me, I'm like, this is me. When I read the Brunner test and all the criteria, I'm like, this is me. Like, I need to do this. So anyway, I digress. I hope we have enough time. I'm like, okay.
Oh, we do have enough time, but I do have another question from the audience.
Okay.
Based actually right on topic about the Brunner test. This person said, regarding undue hardship, I currently don't feel like I can afford the doctors and avoid going for financial reasons, including mental health counselors. I 1,000% can relate to that. But I go out to dinner and go to the gym to help with my mental health. Can you discuss how these circumstances are balanced when analyzing the first factor of the Brunner's test?
Right. So this is like older case law, right? So this is before the new guidance. It was like they would nitpick, like any of your adversaries, whether you're dealing with the assistant U.S. attorney for a direct loan, or you're dealing with like Discover student loans or whoever, they would, and there was a lot of discovery involved. So basically they're reviewing your bank statements, looking at where you're spending your money, and really attacking anything that's not necessary for your survival, right? But even me, I remember when I was going through my case, they were all over my social media. I had gone to a Beyonce concert, VIP. Meanwhile, I didn't even, it was a gift, but still they were like, challenging that. Or I went on vacation with my boyfriend at the time, and I was spending money in Paris and whatever. So they would, if you are spending money on anything that's not necessary for your survival, they're going to attack it. But I still, even with all those things, right? I still got rid of 120K, right? Which wasn't all of it, because I had 156 at the time. So then it was reduced to 36,000, which is a lot better than 156. But I say all that to say, I went to the gym. I went to concerts. I went to Sephora. I did all the things, right? The only other, the main thing, I think what helped me win my case, is that I had to move back, even though after I graduated, I was living on my own. Because I was trying so hard to pay these student loans, I moved back in with my parents. And instead of paying rent or a mortgage, I was paying over $1,000 a month on my student loans. And that was a demonstration of good faith, like paying for almost a decade, $1,000 a month between my private and my federal student loans. So I hope that answers the question. I'm sorry, I get on my soapbox and I just like, so I'm like, wait a minute, did I even answer the question? So,
I think you did. And for now, though, that's the last question that we had. So I guess you can continue with the presentation.
okay.
And I'll keep monitoring the chat as it goes on.
Okay, wonderful. All right, so moving on to the next slide. So these are another slide of just case examples that illustrate the second prong of the Brunner test, which is the additional circumstances. Okay, the last prong is the good faith, right? So this examines the debtor's efforts to maximize their income, right? So before the new guidance, they would look at certain things like your career choices, which would be bad for ministers or any artists, musicians, public interest lawyers, because they would attack your choices and say, well, why are you in public interest law if you could work for a corporation instead? Or why are you out here, teaching music classes when you could, whatever, you know what I mean? So that it was like almost like a morality question, which is ridiculous, which I'm glad now the new guidance eliminates that. Okay. And in the Mosley decision, this is a 2007 case. The court said being too poor to make payments is not bad faith. Okay, so another slide with a bunch of cases that illustrate good faith. I'm not going to go through each in detail. You guys can refer to that later. Okay, partial discharge, which is great in New York. I've seen partial discharge a lot. So courts are divided, but in New York, partial discharge is allowed. So there's a couple of approaches to partial discharge. The first is strict approach. So that's all or nothing, right? So there are two approaches where the courts conclude that 523A8 contains no statutory language that would authorize a partial discharge of a student loan. And in the Conway case, authorizing partial discharge leads to unpredictability and lack of uniformity. That's the strict approach. The flexible approach is the court is willing to discharge a portion of the student loan. So discharge the portion of the loan that created the hardship and require repayment only of the remaining portion. And the debtor, you still have to meet the prongs of the Brunner test, but at least a portion of it could go away. The hybrid approach is when it's on a loan by loan basis, right? So some of them may be discharged while the rest are non-dischargeable. So for income-driven repayment, so participation in an income-driven repayment program is not required to establish undue hardship. So the fact that the debtor can afford the IDR is not dispositive of whether she can maintain a minimal standard of living while repaying her student loans. So prior to the new guidance, and even during my case, when I was litigating my own case, the adversary would always say, well, what's the problem, right? When you're dealing with government loans, they'll say, well, the payment, if you qualify for an income-driven repayment and you can have a $0 payment. So what's the problem? How could that be a hardship? And I would always push back for myself and my clients and say, the $0 payment is bullshit, forgive my French, but like, that's not real. That's just something that the government made up, and a $0 payment while the interest continues to compound daily is really just setting you up, right? It's a setup. So now that is eliminated because the new guidance uses the standard payment only. They're not going to make the argument about the income-driven repayment. All right. So I want to talk a little bit about discovery. And for those, I mean, most of everyone here is either a law student or a lawyer. So you understand what discovery is. It's just basically exchanging information between the parties. So the document request that you can expect to receive from the lender, all financial records, right? So tax returns, pay stubs, bank statements, retirement account statements. And especially now in a cashless world, the bank statements will pretty much tell someone's life story, where they shop, what they eat, what they pay for their rent, what they pay for their medical bills. Like it really paints the picture of the budget. Also, they'll request employment records, proof of debtors' efforts to find work, right? So if someone has been trying for years to get into the industry that they studied for, then if you can show, okay, I sent out, 10 cover letters a day, 10 resumes a day, I've been applying to jobs, I just can't find one. So that is that's good evidence of good faith, right? And efforts to maximize income. Medical records, a lot of times, there's some type of chronic illness or injury that either limits your ability to work, prevents you from working, whatever. So medical records will come into play. And then any proof of expenses, like all the bills, your utility bills, phone bills, things like that. And then usually the opposing counsel will send over release forms, so the tax release form, the form to release employment records, the form to release health records. So as long as you sign off on those, then the opposing counsel can go directly to whoever has those records. So documents that the plaintiff will want to request, the borrower, you'll want to get a copy of the loan records, the promissory notes, the applications for deferment and forbearance, any correspondence between you and the lender, and any documents related to the disbursement of the loan. Okay, so I just want to touch a little bit on student loans in Chapter 13. Chapter 13 is a really useful tool. So let's just get into it a little bit. So the Department of Education has consented to allow debtors to participate in IDR while in a Chapter 13 if it contains certain provisions. Because prior to the Buchanan provisions, if the person was in a Chapter 13, those loans would just be on pause for 3 years or 5 years, and then the interest would continue to accrue, and then they wouldn't get credit for that time for either the public service loan forgiveness or like income-driven forgiveness. But once the debtor decides they're going to do a 13 and they continue to pay their student loans, there's certain language that needs to be included in the Chapter 13 plan. I won't bore you guys with this because this is really more for practitioners. If you want to talk to me about what provisions are necessary, just contact me directly. And this is, again, another slide about the provisions that are required and why the separate classification of student loans is justified. Okay, so one of the beauties about Chapter 13 and why it's important for student loans, especially private student loans, is that there's something called a co-debtor stay in a Chapter 13, right? So everything that applies to the debtor also applies to the cosigner. So there can be no collection calls, no lawsuits, no negative reporting on your cosigner's credit report. So, in instances where you're trying to protect your parent, your spouse, sometimes even if the relationship has deteriorated, right? So between ex-spouses or ex-boyfriends and girlfriends who signed for a student loan, who co-signed for a student loan, and the borrower defaults or is delinquent, and now the cosigner is angry with them because they're affecting their credit or they're getting threatened with lawsuits and things like that, the borrower can protect their cosigner for at least that 3 to 5 year period while they sort themselves out. So even if somebody is eligible for a 7, a 13 may be a better option if there's a cosigner involved. Okay, so now we've come to the last part of the presentation, which is discussing the new DOJ guidance that was released last November that gives a clear step-by-step on how to discharge federal student loans. Okay, so again, and this was announced November 17th, 2022, and the new process, in the press release, they said the new process will leverage Department of Education data and a new borrower completed attestation form to assist the government in assessing a borrower's discharge request. So the attestation form is about a 15-page document that you would sign off on and go through the details without the need for discovery, right? So you can bypass discovery, and that reduces the cost of litigation a lot. Because when I started doing this, and before November of last year, there was depositions, there was interrogatories, requests for production of documents. It was a mountain to move and a long, tedious process. Now that process has been reduced to a 15-page document, and I'll get into the particulars of that document, right? So just a few things, the significance of the new guidance, because the current standard prior to this was arbitrary and unfair. The litigation was often too costly for the debtor to afford, and the guidance seeks to rectify it by setting clear, transparent, and consistent standards and simplifying the process. Okay, keep in mind this is a policy change. This is not a change to a statute or rule. The adversary proceeding is still required, right? So you still would have to file a complaint against the defendants. The new guidance is for purposes of settlement and stipulating to a discharge. And the court does not have to be bound by it, but most judges are signing off on whatever the parties stipulate to. Okay, so it's important to note that this guidance only applies to direct loans. Now, if you guys don't know the distinction between direct loans, FFEL loans, Perkins loans, I encourage you to figure that out before you pursue this process. And if you have anything other than direct loans, then to consolidate into a direct loan before you pursue bankruptcy so that this new guidance could apply. Okay, so, and it applies to any debtors that are in bankruptcy on or after November 17th, 2022, and debtors, of course, in any future bankruptcies. Okay, so the objectives, again, like I said, it wants to ensure access to justice for student loan borrowers, provide clear eligibility requirements, provide a more expeditious process, and reduce the cost of litigation. And I'm not going to go through the Brunner test again because I went through it on the previous slide, but you guys know the 3 factors: minimal standard of living, additional circumstances, and good faith efforts. Again, the totality of the circumstances test, not the rule here in New York, so we're just going to keep it pushing. All right, so when the government is analyzing your request for a discharge, they're looking at 3 things: the present ability to pay, the future ability to pay, and the good faith efforts to pay. So now let's just discuss the present ability to pay, which is essentially the first prong of the Brunner test. So if a debtor's expenses equal or exceed the debtor's income, the department will determine that the debtor lacks the present ability to pay, right? So looking at the budget, they're going to say, well, if your expenses are just the same or more, then you qualify, right? And the IRS standards are used in bankruptcy law in general, but they are also used in the adversary proceeding. So the IRS collection standards have a certain amount that they determine that a certain family size would need for food, clothing, shelter, medical expenses, things like that. So national standards, you're using the same amount as the means test, which we won't get into the details of that, but local standards are limited to the actual expenses, not the full allowable amount. Other necessary expenses and also reasonable expenses not yet incurred. So this is really important because before there was this gray area of what expenses are allowed. But in this instance, now with the new guidance, the the debtor, you're allowed to put down expenses that you're anticipating that you will need, but you haven't yet incurred. Like, for example, if you have a child that you can't afford daycare for, but you're leaving the child with your elderly grandmother who cannot keep up with the child and endangering both of them, right? Like, you really need to be putting your child in daycare, but you just can't afford it. So that daycare expense would be allowed as part of the monthly budget, even though you haven't yet incurred that expense. Another example is if you are trying to move out and you've been living with family or relatives and you need your own place to stay, you can allocate the cost of rent. Or another example, if you need your glaucoma medicine, one of my clients, he had glaucoma and he wasn't getting his medicine because he couldn't afford, like, he literally couldn't afford it. And it's not like he was paying his student loans, but that was one of the points of contention, whether or not that could be part of his monthly budget. Well, of course, if he has glaucoma and he needs, like, that's his eyes, right? Like, that's important. So things like that. If you are foregoing therapy that you need, all the things that you would normally pay for if you could afford it, right? If you didn't have your student loans. And even if sometimes people aren't even paying their student loans, but they can't afford like the basics, like childcare or medicine. So things like that. Okay. So that's all going to be evaluated in the present ability to pay. Okay. So here where, the expenses are going to be compared to the income, and gross income does include Social Security and unemployment benefits in this context. And again, the assistant U.S. attorney has to use the standard monthly payment and not this IDR. Even if your IDR is $0 or $50, nobody cares. They're only looking at the standard payment, which is usually either 10 years if the loan is below a certain amount, usually for people who went to grad school and have a ton of debt, you can have up to 30 years to repay. So it would be the 30-year standard payment. Whatever that monthly payment amount is what they're going to use to evaluate your present ability to pay. Okay, so if your expenses are greater than your income, then part 1 is satisfied. Again, partial discharge may be an option. Okay, future ability to pay. Any one of these circumstances are going to create a presumption that the debtor's ability to pay the student loans is unlikely to materially improve in the future. If the debtor is 65 or older, if they have a disability or chronic injury. Now, this does not mean total and permanent disability, because there is a discharge specifically for that. That's an administrative discharge, not in the bankruptcy. But here, they're not saying the debtor has to be permanently disabled. It's just that if you have a disability or chronic injury. If you've been unemployed for at least 5 of the last 10 years, and if you failed to obtain a degree for which the loan was procured, and if the payment status has been other than in school for at least 10 years. So if you can check any of these boxes, then you qualify and you satisfy the second prong. Okay, the presumptions are rebuttable. Certain things are not rebuttable, right? Like the debtor's age. If you're 65, you're either 65 or you're not. There's no way for them to challenge that, really. And then you would claim all the presumptions that apply, right? So if you fit into more than one category, you would check all of those boxes. Okay, if the presumption does not apply, then you can attest to any other relevant facts or circumstances that speak to your future ability to pay. Okay, good faith efforts, right? So evidence of good faith includes making a payment, applying for a deferment or forbearance, applying for an income-driven repayment plan, applying for consolidation, responding to outreach from the servicer, engaging meaningfully with the Department of Education or the servicer, or if you engage with a third party who you thought was going to help you with your student loans, Some of these companies out there provide student debt relief, or some of them are scamming. They're scamming, but even if they're scammers, if you thought that they were going to help you and you can prove that you were working with them to help you resolve your student loan debt, then that's evidence of good faith. Okay, so other criteria for good faith are efforts to obtain employment, maximize income and minimize expenses, your payment history, enrollment in an IDR. Also, non-enrollment is not controlling, so it doesn't, even if you didn't enroll, then it's not going to negatively impact you. Okay, so the next couple slides are, I'm just going to kind of go through how to fill out the attestation form. So the first part is the personal information. You're going to put where you reside, your household size and structure. So for purposes of federal student loans, your household size includes your spouse and your dependents. It only includes other relatives if you are supporting those relatives, right? So if your parents live in your house and don't pay you rent, then you can have them as part of your household size. Or if your little cousin lives with you and they don't pay rent and you're responsible for them, then you can claim them. But, generally speaking, it only includes your spouse and your dependents. All right, in part 2, you're going to put in the loan information, so the balance of the loans, the current repayment, whatever the monthly payment is, your educational history, and your employment situation. Okay, so part 2 is your household gross income and your monthly expenses. Again, the national standards are going to be used for food, housekeeping supplies, clothing, personal care, and miscellaneous, right? Local standards are going to be used for housing, utilities, and transportation, because those items vary throughout the country. So you're going to use whatever the local standard is for the county you reside in. Okay. Current income and expenses. So other necessary expenses include alimony, child support, babysitting and daycare, and any other allowable, any other reasonable and necessary. Okay. Again, reasonable expenses not incurred. Those examples that I gave earlier, like medicine or childcare, rent, things like that. So if the bankruptcy is filed within 18 months of the adversary proceeding, you can use the items that you put in Schedule I and J, which is part of the initial bankruptcy filing. You can use those numbers and not have to submit new budget numbers. Again, they're only comparing your income and expenses to the standard repayment, not the IDR. Okay. Future inability to pay. Again, these are the factors. I won't reiterate each one, but I'm just going through the different sections of the attestation form. So again, if you can check any of these boxes, then part 2, the future inability to pay, is satisfied. And then again, prior efforts to repay, which is good faith. Any of these things, if you made a payment, if you applied for IDR, if you consolidated or communicated with them in any way, that's evidence of good faith. Prior efforts to repay, so more evidence of good faith would be your efforts to find employment, to maximize your income, minimize expenses, and generally handle your finances. Also, you need to disclose your current assets, right? So if you own a home, the value of the home, the Kelley Blue Book value of your car, your retirement accounts, if you have interest in any business, anticipated tax refunds, and then no dispositive weight is given to non-liquid assets, right? So not like, obviously you need your home to live in, so they're not going to consider that. But if you have a vacation home or a timeshare, then that value of that will be used in the analysis. Okay. And then the last section is for any additional circumstances that you want to add. Okay, so here, this is a list of a few resources that you can look to for assistance or more information. At the top of the list is studentaid.gov. That has anything you need to know about the repayment plans, the forgiveness programs, information about your own student loan accounts. So that is the best resource to go to if you have federal student loans. The next one is the student loan borrower assistance.org. Protectborrowers.org is also a great resource. The National Consumer Law Center, and then the Department of Education Ombudsman. For complicated issues, you can reach out, to that number. And I mean, they're so backlogged, it would take forever to get to you, but at least that's a resource you can use. Okay, and that's the end. And here's my contact information. If you need, any questions answered, please feel free to reach out. I'm really passionate about this and helping you with your student loans, with bankruptcy. I know it's a scary thing, but like, I promise you, I would not be if it wasn't for it saved my life. And the only regret I have was not doing it sooner, right? Because all my hangups around it, and I could never, and all the things. I'm so glad I got over that. So yeah. So any other questions? How are we on time? All right, we got 10 minutes.
We got 10 minutes, but I answered a lot of the questions during the session, but no one has answered the question yet, so we can hang out for a little bit if someone has any more questions. Okay. Or I can talk about and no one has questions, I can talk about the events Metropolitan Black Bar Association have coming up and HALANY. But in the meantime, I'll just pause here for a minute or two. For anyone who may have questions, if you could just put it in the chat, and then we'll just continue from there.
All right, guys, don't be shy. Don't be shy. Even personal questions. I mean, but if now's the time. You got me. I got 10 minutes. So, I mean, if there are no questions, I guess we could let the people go.
Thank you so much on behalf of the Metropolitan Black Bar Association Young Lawyers Division. Oh, wait, there's a question. Okay, I asked a question. Sorry. All right, so the question is, I went to law school and admitted in New York, but currently living in a different state. Can I file for bankruptcy in New York, or do I need to file for bankruptcy in the state I live? And if so, what is the best state to file bankruptcy in?
Well, overall, the best state to file bankruptcy in is Texas or Florida, because they have unlimited homestead exemptions, and sometimes people move there for that purpose. So even if you had like a $2 million home, you could still file Chapter 7 and keep it. But the best place to file bankruptcy is where you currently reside, right? You can't just pick a place. Like the bankruptcy law requires you to file in the place where you are currently residing, right? So I hope that answers the question. It doesn't matter where you went to school. It just matters where you live and work. Well, really where you live, because you could have a remote job where your employer is in California, but you live in New York. Make sense?
Okay, there's a few more questions following that. How would filing bankruptcy affect your application for appointment to a judge?
It shouldn't by law, because they can't discriminate against you for filing bankruptcy. The only time where it's legitimately an issue is if the person works in the financial services industry, right? So if they work on Wall Street, or they handle people's money, or they have, fiduciary duties, then the bankruptcy can legitimately be used against them, I guess. But anything else, no, it should not. But again, we live in the real world. So even though the law says you can't do something, right? Like, using sexual harassment as an example, It doesn't mean that it doesn't happen.
And the last one's more like a statement. It just says, thank you for your guidance and information.
You're welcome. And one thing I, want to point out is that, you know, like when you file bankruptcy, it's not like you'll never get credit again. As a matter of fact, most of my clients, including myself, once the discharge order is signed, you will be flooded with credit card offers. You know why? Because now you're debt free and you don't owe anybody. And they are anxious to get into a new relationship with you where you owe them money and nobody else. So getting a car loan is easier, getting credit cards is easier. The only thing that's a challenge is getting a mortgage, and you won't qualify for a mortgage for at least 2 years. But you're better off after your bankruptcy than you are before, where you're carrying around all this debt that you can't pay. It's like you're a brand new baby when that discharge order is signed. And I don't know if any of you went to school in the 90s or the early 2000s, but I remember those credit card people coming on campus and giving us free pizza and toys and saying, sign here for this credit card application. That's how it's going to feel. It's going to feel very like, ooh, a shiny new plastic. I can go shopping with this. Yeah. Like free money. Right. And that's the thing also that's, terrible about like people from our community. We don't have like that financial literacy and savviness. So, we get into trouble easier. And like I went to school I grew up in a time before Google, right? Before YouTube, right? So a lot of you are way younger than I am, but it's like we just did what we were told, right? Our teachers and our parents told us, go to school, borrow money. This is how you go to school. And like, especially for West Indian folks, Caribbean folks, Haitian parents, they don't play. You going to school, right? And where they came from, doctors and lawyers could be doctors and lawyers without going into debt for it. So they come to America and they tell their kids, go to school, get this degree, and they don't realize the implications of what student loan debt really means. Now there's a lot more financial literacy. We all have all this information at our fingertips. We have YouTube, we have Google, we can learn all the things about being financially savvy. So we're not going to fall for the okey doke like we did when I was 18 and a freshman at Fordham University saying, okay, give me a slice of pizza. I'll sign up for this credit card. We're not doing that anymore. So.
Oh, okay. We actually are at our last question and we have like 4 minutes to spare. I would like to, obviously respect everyone's time and thank you so much on behalf of the Asian American Law Association of New York and the Metropolitan Black Bar Association, Young Lawyers Division, for hosting this two-part series. I know myself personally, I've cherished definitely the first part because we have large student loan debt, and this platform and this program is specifically for that, and we really truly appreciate it. In the chat, I did submit the link for the very first presentation. Once our administrators are able to upload it again, then I will forward all the attendees the second link along with the PowerPoint. I believe you guys all received the first PowerPoint. You guys will receive the second one after today. I believe on behalf of Metropolitan Black Bar Association, please just check out our website for future events. And the Haitian American Law Association has their upcoming gala on November 9th. Please reach out to HALANY at halaofny@gmail.com in order to secure a ticket. Tickets are currently on sale at Eventbrite, and you guys are all welcome. But again, Natalie, thank you so much again for hosting tonight's event. Really, truly appreciate it.
Yeah. I just want to remind the folks, you guys can email me or find me on social media. I'm at My Student Loan Counselor on Facebook and Instagram. So if you have questions, I am here for you. So please feel free to use me as a resource.
Okay.
All right. Have a great evening, everybody.
Have a good night. Thank you so much.
Again.
Have a good one.
Okay. Bye-bye.
Bye-bye.